Hey everybody, John Skiba here, and welcome to Thursday night. Back at it. Sorry I missed you guys last week. It's the getting to the end of the school year, and I've got things from the kids that I've got to help out with. So I hope that, and I also kind of let people know late about tonight, but appreciate anybody who may be checking in. We're going to do like we do each and every week, where we discuss different topics related to debt collection, lawsuits, particularly junk debt buyer lawsuits, bankruptcy, fair debt collection, all that kind of stuff. So how I like to do it is if you have a question or a topic you want to talk about, go ahead and put it in the comment section over there on the side, and I will put it up on the screen and we'll discuss it. As I do each and every week, though, I have my little disclaimer that I am a licensed attorney in the state of Arizona, and I'm happy to meet with people in Arizona and discuss how we can help them. I'm not licensed anywhere else, and I don't know the laws everywhere else. So if you are not in the state of Arizona, I highly recommend you contact an attorney in your state that can help you to answer specific legal questions about what it is that you're dealing with. So with that being said, I'll also put in the comment section there a link to some of the tutorials and templates that I use in the that are more going to a lot more depth that we're going to discuss here today. So, all right. Hey, we got Al right out of the chute. Thank you from Tucson. I appreciate you checking in. And let's jump into some of these questions. All right. We have, I don't want to mess up your name, Katandoya. Had a pretrial hearing with Midland on May 11th. Thanks to you, thanks to me, I submitted a response for arbitration. The Midland lawyer had no idea I submitted a response on April 11th, but Midland changed lawyers 3 times before the hearing. So what happened was the lawyer was speechless when he read the response, and we were sent to the judge. She quickly read the response and granted the dismissal. Awesome. Glad you did that. You're encountering a problem that a lot of these collection firms have. They have usually relatively few attorneys on their staffs, and they're handling hundreds, if not thousands, of cases that they've got to process. They also have a lot of turnover. They usually have a lot of young attorneys who work there a couple of years and then go on to do something different with their career. And so they may not have encountered that, or they may not have responded. Even if you're providing them a copy timely, they may not respond to the motion timely. So congratulations, you did exactly what you needed to do there. All right, let's go on. You said, but as of now, no response from Midland, so I don't know what I should do. Maybe I won. So what you're doing there is, if the judge granted the dismissal, they don't need to respond to it. There's nothing else that needs to be done. The case is dismissed, and then you can pursue it through arbitration or wait for Midland to pursue it through arbitration. There's nothing else you need to do. If the judge actually dismissed the case, then you're good to go. You did win. Congrats. All right. Let's see what Kevin has to say. Hey, John, I received my Chapter 7 discharge a few weeks ago, but curious if there's a standard time after discharge when the case gets closed. Thanks. This is kind of a hot topic right now because I can say traditionally that cases have been closed pretty quickly, usually within 30 days. Some of them will close within a couple days if the trustee's not doing anything. But there's kind of these 2 parallel tracks going on in a bankruptcy. There's just the administrative case where the clerk of the court's pushing this thing through, and as long as all the deadlines have gone by, they'll enter the discharge. Most Chapter 7 cases are roughly 4 to 5 months. Kevin goes on to say it's a no asset Chapter 7. That means that there's no distribution of assets. If there's no distribution of assets, then normally it does. It'll close within 30 days of the case being discharged. And that discharge is the order from the judge saying you're no longer legally obligated on the debt, and then they close it out. The closing is important because what we're seeing right now is cases that do have assets. The trustee, they're leaving these cases open for a long time, and particularly people that have houses, the real estate right now is skyrocketing. And because of that, the danger there is that as it goes up, we've seen some of the trustees then start to pursue houses that are now over the homestead exemption. I think it's kind of a slimy thing to do myself, but legally they can do it. And so that's the thing you have to be careful of, is you want to get that case closed. Unfortunately, there's nothing you or really even your attorney can do to get the case closed. So you can ask the attorney to do it. But there's not a lot that can be done there to force them to do it. The trustee's going to be able to take the time that they need to be able to review the case and determine if there's assets to be liquidated. So, I mean, I literally have cases right now that have been open for 18 months to 2 years after discharge, but that's really rare. It's usually within a month or two afterwards. So, all right, let's see here with the Dreamcatcher. It says, is a debt collector required to show proof of a signature on the contract for the debt to be valid? You know, if we're talking like a credit card, there's got to be here's what you have to do to be able to show that there was an agreement. There has to be some proof that you assented to the terms of it, that you agreed to it. And so the issue that debt collectors run into is often either there is no contract. You know, it's not like the old days where you used to get something in the mail, you'd fill it out and send it back in, and that's how that was the actual contract. Now most of the stuff is done online, or they've just lost it. They don't have the original contract. And so what you'll see debt collectors do is when they file a lawsuit, they will often sue for breach of contract, which is just your run of the mill. Hey, there was an agreement and it was breached. But they'll also sue for what's called account stated, or a stated account, either way. And what that is they're trying to prove a contract by the course of dealing between the parties. So they'll show, hey, look, here's 2 years worth of monthly statements. The defendant was making charges on it, and they were even making payments on it. And if they can show this back and forth that you were making payments, making charges, making payments, then the court can infer what the terms of the agreement are based upon the monthly statements. So that's kind of how they get around it. So I guess the answer really is no, they don't have to show the actual signature on a contract for it to be a valid debt. Now that's different if it's something like an installment agreement. An account stated is going to be a lot harder if it's something where you had a mortgage or something relating to real estate. They're not going to be able to do that. But the typical contract thing, unfortunately, that is the case. All right, let's see here. Ransom says, I just submitted an offer in compromise for the IRS. I am partially self-employed, and so they're asking me to pay $2,700 in quarterly taxes by June 8th, 2022. What is the likelihood that they will grant an extension on this? You're veering outside my areas of knowledge. I know enough about offering compromises with the IRS. I for sure don't know tax law, but with the offer in compromise, I know that the IRS is very strict on the deadlines as far as having returns filed, making sure that the current taxes are current, and getting them approved. So that being said, I always say it doesn't hurt to ask, but my experience with the IRS when it comes to offering compromises is they take the position of, hey, we're going to get rid of a bunch of this tax debt. You've got to be totally current on everything going forward. Otherwise, we're going to revoke it or deny it altogether. So Angie's here today. Angie, how are you doing? Same with Alex. Thank you. Down in Yuma. It's already getting hot in Arizona. It's like 105 today or something crazy. Sometimes I don't know why I live here. All right, let's see what Lady Cash said. It said, I request for my original credit card agreement and all transactions, which was not provided, but the judge ruled against, and you want to appeal. Your thought? The one thing to understand about an appeal, typically an appeal of a judgment does not mean that you are retrying the case, that you're going to get a whole new trial at the Court of Appeals. You're not. What the Court of Appeals, or whether it's a panel of judges or a single judge, they're going to go through and they're going to look and see, did the judge who handled the underlying case, did they make any mistakes? Did they abuse their discretion? That's the standard that they're usually going to look at. And the reason why that's important is because if you go to trial and lose, the appellate court's going to look to see, did the judge go so far outside the bounds of what's acceptable that we're going to overturn it? I've heard appellate judges say, look, I may not have ruled that way, but I understand why they did what they did. And so I don't feel that they abused their discretion. It was within their discretion to rule the way that they did. So if they didn't provide you all the transactions, the court's not going to require that. They've got to show some proof of how they came up with damages, but they're not going to require that all of the transactions be provided, as well as the original credit card agreement. Those things alone generally are not the things that win cases. So, all right, let's see here. See what Kevin has follow-up. You're in Texas, so I believe the exemption for the home is unlimited. Does it take a bit longer if there's exempted property? that needs to be reaffirmed, going on 15 days from discharge. And this is going back to the question of how long does it take them to close the case. Usually, reaffirmation agreements, those have to be dealt with prior to discharge. So if the discharge has been entered, there may be no reaffirmation. The court's not usually going to keep it open unless the court has actually set a hearing on it. So 15 days from discharge would be actually generally super quick, at least in Arizona, for it to happen. So it doesn't surprise me that it's not closed out completely yet. And you are lucky to have the unlimited homestead exemption. I believe Texas and Florida, I believe, have unlimited homestead exemptions, which helps that out quite a bit. So, all right. Let's see what Serena. Can a debt collector keep raising the balance on an account? The new balance is now $4,000 higher than the original amount when the account went into collections. Yes, they can. They can keep charging interest, whatever the contract rate of interest was on it. And usually once an account goes into default, the interest rate jumps up to, 25, 30%. And so it just starts churning interest and it just gets really out of control. But whether it's the original creditor or whether it's a debt buyer, they're bound by the terms of the agreement. And if the agreement allows for interest and penalties and all that kind of stuff, yeah, unfortunately, it's going to keep getting bigger on that. So, all right. Christina says, I have recently discovered that I have a judgment against me. When I didn't know, I had 30 days to respond. It's for a Capital One credit account. I'm on Social Security, disability. What are my options? Well, your options, I always say there's three options when it comes to judgments. You can settle it, you can fight it, or you can file bankruptcy on it. There's a fourth option, which I don't give to too many people, and that's you can do nothing. Your first option, you can fight it. You can see how it is that they got the judgment. You have to go in and get what's called the Affidavit of Service or the Certificate of Service, see how it is that they're claiming they served you and see if there's anything you can do to attack that, to kind of get things unwound. That's through what's called a motion to vacate the judgment. You have to have a legal basis to do it. It's not just because you want it, but you have to go and take a look at that. You can settle it. You could reach out to them and offer some lower amount than what it is that they're seeking to get them to stop doing it. You can file bankruptcy on it. If you file bankruptcy on most credit card debts, unsecured debts, they go away completely. Or the fourth option, sometimes you can do nothing. Kind of depends on what your situation is. Like Social Security, they cannot garnish your Social Security. But if you're getting employment income on the side as well, they can garnish that. You have to look at things like if you own real estate, they may be able to put a lien on your real estate. So the Social Security is one thing I look at when deciding if someone has the ability just to do nothing. It's always a little unsettling because they're still out there. They're still going to be able to try to collect on it, even if they can't garnish it. So those are really the options that you need to take a look at. All right, Alex, thank you. As always, I find myself on the creditor side. Oh, here we go. Creditor side. Do you or one of your colleagues take disputes regarding construction contracts supporting from Yuma AZ? I do not represent creditors. I would never do that. But as far as like construction type things, there are people in my law firm. You should shoot me an email or a message through the site, and I'll get somebody to reach out and give you a call. Bob says, I have a collection that's 9 years old, but it won't drop off because every time a new agency buys it, the old debt, they put it back on my credit report. So this is something that is not legal that they're doing, and that you should dispute through the credit reporting agencies. It's called re-aging. So when a debt buyer buys a debt, so let's say like somebody like Portfolio Recovery, they buy a debt. They are, again, this is their own allegation. They're stepping into the shoes of the original creditor. And so when the original creditor charges it off or puts it into collections, they should have to adopt that same date if they buy it and put it on the credit report. But what I see they often do is they'll re-age it. So, let's say that the Citibank card goes into default and goes into collections in December of 2018, and then junk debt buyer buys it 3 years later in December of 2021. Sometimes you'll see the debt buyer they'll re-age the debt. They'll make it look like it just started in 2021. You need to dispute that through the credit reporting agency and show them, look, this thing's already been on here for 3 years. They can't re-age it. You might even be able to file a claim against them through the Fair Credit Reporting Act. So that's something to take a look at. All right. Amber says, I was summoned to court I did not admit or deny the debt, but can I still rebut the debt, collector's affidavit, or is it too late? So this sounds like the court process is maybe a little bit different than ours. If you filed your answer and then they filed an affidavit, usually what happens is they file their complaint, you file a response, and then at that point, it goes into a discovery period, and then eventually it'll go to a trial. But usually before it goes to trial, they'll file something called a motion for summary judgment. They're going to attach that affidavit, and usually it's 30 days. You'd have to look at your local rules to file a response, and that's when you would attack the affidavit. You can't just, generically just kind of attack the affidavit if you're not in summary judgment stage or in a trial stage. So those are the kind of things that you need to take a look at to deal with that. Amber, thank you. That was very nice of you. I appreciate that. All right, the Mary Lander. What if the bill of sale is 3 months later than the time they apparently purchased it? It's very generic as well, and the signatures aren't readable. That is very normal. That the bill of sale, super generic. I always say go through the bill of sale line by line. If the dates are off, and I've literally seen this where the dates don't match up. I've seen affidavits where the person who signed it is different than the person listed in the first paragraph. Go through them very carefully. They do these things in huge volume, and they make mistakes. The Consumer Financial Protection Bureau went through them, and it has even shown that they intentionally, or also, I should say negligently, were doing things without having any knowledge of what they were doing. So those are the types of things you can kind of pick apart if you're in summary judgment or if you're in trial, to show that there's questions. There's questions of the underlying facts of whether they're the actual owners of the account. All right, let's go to Lady Cash here. When is the statute of limitations active? It is when the creditor filed or when the defendant was informed about the case. So the statute of limitations, and this is a good question because this is a question people struggle with a lot. The statute of limitations is the amount of time that a creditor has from the time when the account goes into default until they can sue you. So, for example, in Arizona, the statute of limitations on a credit card is 6 years. That means the time when your credit card goes into default, which is usually about 30 days after you stop making payments on it. So you stop making payments, 30 days later, the clock starts ticking. That 6 years is ticking. They have 6 years to file a lawsuit against you. If they file the lawsuit at any time within that 6 years, they're within the statute of limitations. But if you stop making payments, a month goes by, 7 years goes by, and then they file the lawsuit, it's too long. You can file a motion to dismiss. You can probably file a Fair Debt Collection Practices Act lawsuit against them for suing you on a debt that you do not owe. But it's got to be longer than 6 years from the time that the account went into default. Now, there are some jurisdictions where you can reset the statute of limitations if you make a partial payment on it, if you acknowledge the debt in writing, if you were to sign something and say, yeah, this is my debt kind of thing. Arizona had a case come out not too long ago that said that you have to bring the account completely out of default in order for it to restart that statute of limitations. So if you're behind on your credit card by $2,500 and it was in default, you're not going to reset the statute of limitations by making a $20 payment. Still don't think I would do it, but that's the period, the statute of limitations. Now, a lot of people get this confused with once the judgment gets entered. So they file the lawsuit and then there's a judgment that's out there. And then 10 years later, they're still trying to collect on this judgment. Statute of limitations is something different. Statute of limitations is before the lawsuit's filed. Once the judgment's entered, each state has different laws as far as how long that judgment is good. So in Arizona, a civil judgment is good for 10 years from the date that the judge signs off on it. And then it can be renewed every 10 years for the rest of your life, as long as they file the paperwork timely right before it expires. So that's something different. Once the judgment's entered in Arizona, they can go on forever. It's something you got to deal with. And that's why I'm saying, I talked about that do nothing option. Rare when I particularly in Arizona, where I say that's an option, because this judgment will be out there just bugging you for forever. So hopefully that helps with that. That's a big one that a lot of people struggle to understand. So, all right, I think that'll do it for this Thursday night. Appreciate everybody checking in as always. If you have other questions, go ahead and put them in the comment section. I do try to pull some of those out each week, and we can address them. Or there's a ton of other videos online, or check out the online tutorials that I put there in the chat section on YouTube. That'll give you some greater information on what we're doing today. And hey, if you haven't subscribed, please do so. I would appreciate it. We'll catch you next week.